Hi, it's Roland Jones. This is another video in a series of short videos on preference and fraudulent conveyance issues. This video is about Goodman versus the Credit Union of Georgia. Um, and the question is, was a payment to the credit union by this individual in the ordinary course or not? Most people spend a lot of time looking for what's extraordinary in life, but preference defense lawyers always try to find what's ordinary. We look for what's ordinary because the ordinary course defense is one of the defenses to a preference lawsuit. If the transfer is found to be ordinary in the ordinary course, then the defendant does not have to pay back the clawback. In this case, this was a member of a credit union who borrowed money, had a checking account, savings account, credit card, and eventually ran into financial issues and filed Chapter 7. This case is a little bit unusual because when this person filed for bankruptcy, the credit union started a proceeding in bankruptcy court to find that this person had used her credit card fraudulently, and that the debt was incurred in fraud. And so they sought to have this particular debt non-dischargeable. In other words, she could not get rid of this debt by filing bankruptcy. And apparently they had some kind of good cause because she entered into a consent judgment with them and agreeing that even though she went bankrupt, the debt to this credit union could not be discharged. What happened after that is that she came to an agreement with the credit union instead of being sued again, that she would settle the debt and pay the credit union. Apparently, she ran into financial trouble again with other creditors, and she filed Chapter 13. After the 13 case was started, a trustee was appointed, and the trustee sued the credit union for clawback. And the trustee said the credit union was paid in the 90-day preference period, and that these payments were a preference, and the credit union was a preferred creditor. The credit union argued that these payments were in the ordinary course; they're just typical credit card usage, and so the case should be dismissed. The trustee argued, "Hey, you already sued her, alleging that the debt was incurred through fraud, so it can't have been incurred in the ordinary course." The applicable section is here, 547C. The trustee may not avoid under this section a transfer to the extent that such transfer is a payment of a debt incurred by the debtor in the ordinary course of business. So here we're talking about this particular phrase, incurred by the debtor in the ordinary course of business or financial affairs of the debtor. So the question is a debt like this, where there's a consent order establishing that the debt, that the credit card debt was incurred in fraud, could this somehow be, could this have been paid in the ordinary course anyway by the debtor to the credit union? Not too surprisingly, the court found that it could not be a payment in the ordinary course. That was not incurred in the ordinary course because the debt had already been established to be fraudulent, and the debt was incurred as a result of fraud. So the credit union kind of shot itself in the foot by making that motion previously, and then not realizing that it would then or could then possibly be sued for a preference, and basically destroying its own ordinary course defense. Also, the court noted that the payment was the result of a settlement under threat of lawsuit, and the court also doubted whether such an extraordinary circumstance could be in the ordinary course. But the focus was that the debt was incurred by fraud, and that could not be in the ordinary course, and that's the case for today. The result is a debt which results from fraud cannot be held to have been incurred in the ordinary course of business or financial affairs of the debtor and the transferee. This actually is an extremely important issue because a lot of Ponzi schemes file for bankruptcy, and a lot of trustees sue recipients of payments from Ponzi schemes. And unfortunately, it's a law in every bankruptcy court in the country that if you get paid by a Ponzi scheme in the preference period, it cannot be in the ordinary course because the debt was incurred in fraudulently. So it can't be ordinary course. And this is really disastrous for a lot of preference defendants, especially in the context of Ponzi schemes.